Hello students, welcome to today's lecture on the overview of changes introduced by the Bharatiya Nagarik Suraksha Sanhita 2023. As this is in your knowledge already that our existing criminal laws are very soon going to be replaced by the new criminal laws. The Indian Penal Code 1860 has now become the Bharatiya Nyaya Sanhita of 2023. The Code of Criminal Procedure 1973 has now become the Bharatiya Nagarik Suraksha Sanhita 2023. And the Indian Evidence Act of 1872 has now become the Bharatiya Sakshi Adhiniyam of 2023. There is some confusion in the student community that whether it is the new laws, these three new laws which are already in force, or for their judicial service examination or university and college examination, they still have to study the existing criminal laws. So on this point, I would like to tell you a couple of things. If you look at the Bharatiya Nagarik Suraksha Sanhita 2023 and the Bharatiya Sakshi Adhiniyam 2023 and its section 1 subclause 3 of both these legislations, it is very categorically stated there that it shall come into force on such date as the central government may by notification in the official gazette appoint. That means that these new laws, they are already published in the official gazette, but they have not yet come into force. Their date of enforcement is going to be decided and declared. The date of enforcement is going to be declared soon in the official gazette. Right now in the official gazette, these laws are only published. Similarly, if you look at section 1 subclause 2 of the Bharatiya Nyaya Sanhita, it says the same thing. Now, additionally, if you refer to the last section of all these three laws, last section will be repeals and savings. If you refer the last section of all these three laws, there you will clearly see that it is mentioned that till the time new laws come into force, the existing criminal procedure, the existing regime regarding substantive offenses is going to be governed by our existing criminal laws only. So for judicial service aspirants, I must specifically tell you that till the time State Public Service Commission, or for the states where the High Court is conducting the examination, judicial service examination, till the time High Court or State Public Service Commission notifies it in their syllabus, till that notifies the new three laws in their syllabus, up until then, the old examination is going to be conducted as per the existing criminal laws only. Right? Few students had approached me asking that the existing books and commentaries which they have purchased on these existing criminal laws, whether after new laws coming into force, whether they are going to be redundant and outdated. So on this point, I must tell you that not all the bare acts which are there, they are going to become redundant and you will have to purchase the new bare act. But so far as books and commentaries are concerned, see, the foundation of these new criminal laws is same as that of the existing criminal laws. The foundation is same. However, certain changes in the periphery are introduced. So with respect to the change sections which have not changed in their text, because section numbers are definitely going to be changed, the structure of the bare act is going to be changed. So bare act becomes redundant. But so far as the commentary of a particular section is concerned, with respect to the unchanged provisions, the existing commentary will hold good. The existing judgments of the Supreme Court and the respective high courts are going to hold good, right? So it's not that your entire books and commentaries are going to be waste. That is not going to happen, right? But however, bare acts, since the structure of the laws is going to change, the bare acts are going to become redundant for you. You will have to purchase the new act, right? Now, today's lecture is going to be on the Bharatiya Nagarik Suraksha Sanhita 2023 and the changes which are introduced by it. Right. So see, the foundation of the existing CRPC, you will find it in the Bharatiya Nagarik Suraksha Sanhita 2023 as well. However, there are certain changes which are introduced to make the entire procedure victim-centric, to ensure that there is speedy disposal of cases, to ensure that the investigation is conducted more on scientific lines by involving forensic experts. Then there are certain colonial terms and references in the existing Code of Criminal Procedure which are now not finding the place in Bharatiya Nagarik Suraksha Sanhita. Then if you see that the entire CRPC, The BNSS, which is the Bharatiya Nagarik Suraksha Sanhita, makes an attempt to make CRPC little more fair, little more reasonable, and little more just. And then audio video electronic means recordings are made mandatory through audio video electronic means. Communications which were sent to the court or by the court, they can be now sent through electronic communication. So these are the changes which are introduced. However, the foundation remains same. So I will not be wrong if I say that the BNSS is old wine in a new bottle with certain changes introduced in it. Now let us go through the changes which are introduced. See, one thing I must tell you that I am not going to deal with each and every single section in which the change has been introduced. However, this lecture is about the overview of the changes. So whatever major changes are introduced, those changes we are going to study. Now let's have a quick overview of the changes that are introduced by BNSS. First change you see is that for several minor offenses, community service now can be awarded as punishment. What is community service? Community service means a work which is beneficial for the community, for which no remuneration is going to be provided. So the accused will have to work for the benefit of the community without any remuneration. Second change is that certain definitions are now added in section 2 of the Bharatiya Nagarik Suraksha Sanhita. For example, in existing CRPC, there was no definition of bail. Although there was a fair understanding of bail, bail is conditional release of a person on custody, but it has not been defined. Now, new BNSS provides a definition of bail. It provides definition of bond and bail bond. Then there is definition of audio, video, electronic means, and then there is definition of electronic communication. Next change you will find is in the hierarchy of court. Hierarchy of criminal court is made uniform across the country. In existing CRPC, you will find for metropolitan area there is a metropolitan magistrate. Now, which is equivalent to the competency of metropolitan magistrate is equivalent to judicial magistrate class 1. Now there is no metropolitan magistrate and no metropolitan area in the entire BNSS. There is only judicial magistrate class 1. And there is no assistant session judge in BNSS as it is existing in Code of Criminal Procedure. Next change is that the competency of the magistrate to award punishments is enhanced. If you see in existing CRPC, judicial magistrate class 1 can award a maximum punishment of 3 years and or maximum fine of rupees 10,000. Now judicial magistrate class 1 can award maximum fine of 50,000 rupees. However, competency to imprison a person, that remains same, that is still 3 years, but fine is revised to 50,000 rupees and or he can also award community service as punishment for minor offense. Judicial magistrate class 2 in existing CRPC can award a maximum punishment of 1 year and or fine of rupees 5,000, but now he can award a maximum fine of rupees 10,000, and also in case of certain minor offenses he can award community service by way of punishment. Next change is limit on consecutive running of sentences. This change is reflected in section 25 of BNSS. Now, if an accused, to give a context of what is meant by consecutive running of sentences, if accused is punished for 2 or more offenses, let's take an example of 2 offenses. If accused is punished of 2 offenses in the trial, then the punishment for these 2 offenses can run concurrently also, or it can run consecutively also. Concurrently means both punishments will run at the same time parallelly. Consecutive running of sentences means first he will serve the punishment for offense number 1 he has committed, and then after that he will serve the punishment for offense number 2 he has committed. Now in old CRPC, in existing CRPC, the limit on consecutive running of sentence is 14 years. Now this has been increased to 20 years. However, I also must tell you, CRPC has not given any guidance that in what cases there shall be consecutive running of sentences, in what all cases there shall be concurrent running of sentences. However, if the offenses are committed in the course of same transaction or they are similar offenses, there is concurrent running of sentences. But if it is consecutive running, the maximum punishment, maximum upper limit is 20 years. Next change is introduced by section 176 of BNSS. Now, for offenses where the punishment is more than 7 years, the offenses which are punishable with the imprisonment of 7 years or more, in such cases, the forensic investigation of the case has been made mandatory. It is mandatory on the police officer to call a forensic expert to get the videography of the entire investigation process, right? So forensic investigation is now made compulsory for offenses which are punishable with more than 7 years. The next change is that the statement of victim of sexual violence has to be now compulsorily recorded through audio video means. This change is reflected in section 176 of the Bharatiya Nagarik Suraksha Sanhita. Next change you will see in section 20 of BNSS, that is independent directorate of prosecution is also now established for districts. Now I will tell you what is, briefly I will tell you what is directorate of prosecution. So you see that there is directorate of prosecution which is provided in existing CRPC section 25A, and all the assistant public prosecutors, all the additional public prosecutors and special public prosecutors, they are subordinate to the directorate of prosecution. In existing CRPC, this directorate of prosecution, there was no provision for this directorate of prosecution with respect to districts. Now the new law provides for the directorate of prosecution at district level also, and the functions of district directorate of prosecution is now also specifically provided in different subclauses of section 20, which were not clearly spelled out in the existing CRPC section 25A, right? Then the next change that you will find is in the provision relating to FIR. Now, by way of practice, a concept had come up in the existing CRPC, that is zero number FIR. Zero number FIR means what? An FIR which is lodged beyond the territorial jurisdiction of the police station in which the offense is committed. So if the offense is committed under the jurisdiction of police station A, the FIR of it is lodged in the jurisdiction of police station B, right? So FIR lodged beyond the jurisdiction of the police station in which the crime is committed, that FIR was lodged in zero number. Now this zero number, there is no specific provision of zero number FIR in the existing CRPC. However, this zero number FIR had evolved, it had come into existence by way of practice. Now, the existing BNSS has made this provision that irrespective of jurisdiction, the FIR has to be lodged. Lack of territorial competency is no bar to lodge the FIR. Police officer now cannot refuse to lodge FIR on the ground that the offense is committed beyond its territorial jurisdiction. So this is a very welcome provision. So victim can approach any police station now where a cognizable offense has been committed, get its FIR lodged, and within 24 hours, this FIR has to be sent to the police station under the jurisdiction of which the offense has been committed. So within 24 hours, this FIR will be transferred to the concerned police station under the jurisdiction of which the offense is committed. Now there is also a provision of EFIR. Now this provision is going to be helpful for the victims of sexual violence, because they are hesitant. Victims of sexual violence are hesitant to go to the police station because of the social stigma that is attached to the sexual violence. So what now they can do is they can lodge EFIR. For example, they can get the FIR, they can send a mail reporting the entire incident, right? And this EFIR has to be signed by the victim within 3 working days. So if you are sending your EFIR today, then within 3 working days, you can go to the police station and sign a physical copy of the same. So not only for sexual offenses, EFIR, it will be beneficial for the victims of sexual offenses. However, it can be lodged with respect to any cognizable offense. And within 3 working days, you can go to the police station and sign a copy of it. Next change has been introduced by section 173 of the Bharatiya Nagarik Suraksha Sanhita. For offenses which are punishable with the imprisonment of more than 3 years and less than 7 years. Now, in such cases, preliminary investigation can be conducted to see whether there is a prima facie evidence that the offense has been committed or not. See, Lalita Kumari versus State of UP, 2013 Supreme Court judgment, in which the court has dealt with this point of preliminary investigation. Now this has been incorporated under section 173 of the Bharatiya Nagarik Suraksha Sanhita. So police officer, for the offences which are punishable with more than 7 years, 3 years and less than 7 years of punishment, police officer has the power to conduct a preliminary investigation to see whether the offence has been committed or not, and he has to complete his investigation, preliminary investigation, within 14 days. And if he finds in its investigation that the offence has been committed, then he should come back to the police station and register the FIR. Next change, you see that there in existing CRPC, there is a provision where the state can withdraw prosecution against a particular accused. But now, if you read section 360 of the Bharatiya Nagarik Suraksha Sanhita, you will find that the court is not going to allow the state to withdraw the prosecution without hearing the victim. As I was telling you, that attempt has been made to make the BNSS more victim centric. So no withdrawal shall be permitted without hearing the victim. Next change you will find in section 193 of the Bharatiya Nagarik Suraksha Sanhita, that the copies of police report has to be given, police report, which is also known as charge sheet. So the copies of it shall be given to the victim, and the victim should be informed about the progress of the investigation within 90 days. In existing CRPC, the copies are to be given to the accused, but now victim is also entitled to a copy of the police report, and he should be informed about the progress of the investigation within 90 days. The next change you will find in section 193 of BNSS. Now, if you recall existing CRPC, section 173 subclause 8, there after filing the police report, that is the charge sheet, the police officer reserves the power to conduct further investigation. That means if the police officer has completed his investigation, if the police officer was investigating a particular case, he files the charge sheet. So charge sheet is filed, but he wants to continue with further investigation in a case, for which he can file supplementary charge sheets later on. So there is one original charge sheet, then there will be supplementary charge sheets with respect to the further investigation he is doing, right? Now, this section 193 says that if police officer has decided to conduct further investigation, that means he is investigating further despite of submitting a charge sheet in the court, he is investigating further, then that further investigation has to be completed within 90 days and a charge sheet has to be filed within 90 days. If you want to do further investigation beyond the period of 90 days, then in that case, the leave of the court, the permission of the court has to be obtained. In existing CRPC, there is no upper limit to further investigation, but now upper limit to further investigation has been introduced. Next change you will see in section 233 of the Bharatiya Nagarik Suraksha Sanhita, that magistrate has to decide whether he is going to take cognizance or not within 14 days. And within 14 days, he will have to ensure that the copy of police report and all the other documents are supplied to the accused and the victim. If you see existing CRPC, section 207 and section 208 also, they provide for supply of the copies of the document to the accused, right? So before the trial starts, what all documents have to be supplied to the accused? A copy of charge sheet, that is police report, has to be given to him. If there are any witnesses who are examined under section 160, then the records of the examination should be given to the accused. If there is any confessional statement, it has to be supplied to the accused. The copy of FIR and all other relevant documents which the accused needs in order to prepare for his defense have to be given to the accused, right? So now it says that whether the cognizance will be taken, whether the magistrate is going to take cognizance in a case, because magistrate is not bound to take cognizance on police report. This you already know. If a police officer has filed a police report before the magistrate, magistrate has variety of options on receiving the police report. Magistrate can take cognizance on police report, magistrate can decline to take cognizance on police report, or magistrate can say that I'm not happy with the way the police officer has conducted investigation, so kindly properly investigate the case. So he can pass the orders of proper investigation, right? But if magistrate, whether he is deciding to take cognizance or not, this has to be decided within 14 days, and he has to ensure that all the relevant copies which the accused needs of the documents in order to prepare for his defense have to be submitted to him, have to be handed over to him, supplied to him, and also the victim of the case within a period of 14 days. All the inquiries and trials now can be conducted through electronic mode. Next change is introduced in section 105 of the Bharatiya Nagarik Suraksha Sanhita. Now see, presently what happens is that, see, if police officer wants to, plant a weapon or plant a contraband substance or narcotic substance at the accused's place, right, in order to implicate him in a frivolous case, then it is not difficult for him. But now they have introduced a provision under section 105 of the Bharatiya Nagarik Suraksha Sanhita that if there is search and seizure that is happening, then the video recording of search and seizure process is now compulsory. So, although it is still not difficult to fabricate a case against a particular person by the police, they can still plant weapons. But however, a safeguard has been introduced that the video recording of search and seizure process has to be conducted. Then summon or warrant now can be sent through electronic communication. They can now, presently there was only provision of sending summon or warrant through a post, but now they can be sent through electronic communication also under section 63 of the Bharatiya Nagarik Suraksha Sanhita. Next change is that there is timeline which is prescribed for discharge applications and for framing of charges and deciding discharge petitions. You will see these changes in section 250 and section 262 of the Bharatiya Nagarik Suraksha Sanhita. In existing CRPC, there was no specific provision that the accused can make an application for discharge. Now, to give a context of this change, see, when the trial starts, it is the prosecution who will get the opportunity to open up the case. So, prosecution opens up the case and prosecution displays all the evidences before the magistrate which it has got against the accused. But if magistrate finds that after considering the evidence which the prosecution has put before the magistrate, if the magistrate is convinced that looking at this evidence there is no prima facie case against the accused, then magistrate can immediately discharge the accused. If there is a prima facie case against the accused, then magistrate will not discharge, rather he will frame charges against the accused. But now, accused can make an application for his discharge to the magistrate, right? And there is timeline also imposed for that. For example, if it is a matter which is triable by the court of session, then discharge application can be made from 60 days. From which? 60 days from when? 60 days from the date of committal of the case to court of session. See, some court of session does not try the offence in its original jurisdiction. First, a lower court will take the cognizance of the case and then it will commit the case to court of session. So, from the date of committal, 60 days, the discharge application can be made. If it is a matter which is triable by the magistrate's court, then 60 days from the date of supply of copies to the accused. I told you previously that all the relevant copies, all of the documents which the accused might need in order to prepare for his defense have to be supplied to the accused or the victim. So from 60 days of the supply of copies, the accused can make a discharge application during these 60 days. Next change is introduced by section 356 that now the trial, inquiry and pronouncement of the judgment can happen even in the absence of the accused if the accused is a proclaimed offender. So no presence is required. Inquiry, trial, judgment can be pronounced, can be conducted in absentia in case of a proclaimed offender. Next is that the first time offender. Now see, I'll give a context of what this section is. The change is reflected in section 479. It actually provides for how long you can keep a under trial prisoner in jail without giving him bail, right? So it says that for first time offenders, the maximum period for which a person can be kept in detention in jail is 1/3 of the sentence that is provided for the offense. So if let's say I am the first time offender and I've committed an offense which is punishable with the maximum imprisonment of 9 years. So without granting me bail, what is the maximum duration for which you can keep me in jail is 1/3. That is 1/3 of 9 years is 3 years. So maximum duration for which a first time offender can be kept in jail without granting any bail is 1/3 of the maximum sentence that is provided for the offense. If it is any other case, then it is half. That means, let's say if I'm a repeat offender, second time I've committed the offense, if the offense is punishable with 10 years maximum, then for how long you can keep me in jail? It is 1/2. In the existing CRPC, there was no special provision with respect to first time offenders, although you will find a corresponding provision to this section 479. But for first time offender, there was no specific provision like we have now, that 1/3 of the maximum punishment, right? The next change is introduced by section 258 of BNSS. Earlier, what used to happen was, sometimes after completing the hearing, court usually reserves a day court usually reserves the judgment, and on a future day they will pronounce the judgment, right? And judgments were not pronounced for months together. Now, after completing the hearing, the magistrate has to pronounce judgment within 30 days and maximum 45 days after conclusion of the hearing. So within 30 days, and with recorded reasons, maximum you can push it to 45 days, maximum within 45 days, now the judgment has to come. Next change you will see is that in the existing CRPC, any third party or any NGO also can file mercy petition with respect to an accused who is awarded death penalty by the Supreme Court, right? But now they have made a provision that mercy petition can be filed either by the accused himself, or it can be filed by the legal heir of the accused or the relative of the accused. But a non-interested party, non-concerned party like an NGO cannot file mercy petition on behalf of the accused. And this mercy petition has to be filed within 30 days after the Supreme Court has given its decision. Next change is with respect to summary trials. You will find this change in section 283 CRPC, 283 BNSS. In existing CRPC, what are the offenses with respect to which summary trial can be conducted? Summary trial can be conducted with respect to the offenses which are punishable with the maximum imprisonment of 2 years. Now this 2 years is now enhanced to 3 years. So summary trial can be conducted with respect to offenses which are punishable with the maximum imprisonment of 3 years now. So this is a step taken towards ensuring the speedy disposal of cases. Now with respect to more number of cases, summary trial can be conducted as the maximum, as the offenses with respect to which summary trial can be conducted is now raised from 2 years to 3 years. Next change you will find in section 218 of the Bharatiya Nagarik Suraksha Sanhita. Now what used to happen is that if an offense has been committed by the servant of the central government or a state government, a public servant, if the offense has been committed by him, during the course for some act which he has done, if the public servant has committed an offense during the course of discharge of his official duties, and if you want to prosecute him for that offense, the sanction of the government has to be obtained. So if he is a state government employee, sanction has to be obtained from the state government. If he is a central government employee, sanction has to be obtained from the central government. Now, in certain cases, it has been observed that for years together, central government, they don't give sanction to prosecute their employees. The state government is not giving sanction for the prosecution of this employee, public servant. So now, if sanction is not given by the concerned government within 120 days of committing the offense, then it will be presumed that there is permission. Sanction means permission. Permission will be presumed, and the trial, the prosecution of this public servant will start happening. The next is proclamation of the offender now can be done with respect to 120 offenses. Now I will give you a context of this. If you look at existing CRPC, what are the offenses with respect to in which a person can be proclaimed as offender? So in existing CRPC, there is a list of, if I'm not wrong, it is section 80 CRPC. There is a list of offenses, 1920 offenses are listed there. Only in such offenses, with respect to such offenses, a person can be proclaimed as offender. But now what they have done is, that a person can be proclaimed as an offender, proclaimed offender, with respect to any offense in which there is the punishment of more than 10 years provided. So if there is an offense which is punishable with the punishment of more than 10 years of imprisonment, with respect to any such offense, a person can be proclaimed as a proclaimed offender. Accused can be proclaimed as a proclaimed offender. So earlier 1819 sections offenses were listed only with respect to which proclaimed offender provision was there. But now for any offense which is punishable with more than 10 years of imprisonment, a person accused can be a proclaimed offender. So now if you see, with respect to almost 120 offenses, proclamation of the offender can be done. Next is, now it is mandatory, right? The state governments are instructed to prepare a witness protection scheme, and they will have to be notifying it. They will have to notify the witness protection scheme. This is reflected in section 398 CRPC, 398 of BNSS. And another section is, this is entirely a new section that has been added. This is section 107 of the Bharatiya Nagarik Suraksha Sanhita, that if there is a property which is obtained or derived directly or indirectly as the result of a criminal activity, then this property can be attached, right? And whatever money that this property will generate can be distributed, will be distributed between those who are affected by the crime. And if there is any surplus proceed, then the surplus proceed will be forfeited by the government. So any property which is the proceed of crime, or which is directly or indirectly obtained from a criminal activity, it can be forfeited, attached, and the proceeds of it will be distributed between those who are affected by this crime. So with this, we'll end today's lecture. Thank you so much. And one more very important information for all of you, that now, from now onwards, lectures will be recorded, will be available on the channel in both English and Hindi. And there will be two separate playlists for Hindi, lectures in Hindi and lectures in English. So from today, these lectures will be available in both the languages. Thank you so much.